Welcome to the She Said Privacy, He Said Security podcast. Like any good marriage, we will debate, evaluate, and sometimes quarrel about how privacy and security impact business in the 21st century.
Hi, Jody Daniels here. I'm the founder and CEO of Red Clover Advisors, a certified women's privacy consultancy. I'm a privacy consultant and certified informational privacy professional providing practical privacy advice to overwhelmed companies.
Hello, Justin Daniels here. I am passionate about helping companies solve complex cyber and privacy challenges during the life cycle of their business. I am the cyber quarterback helping clients design and implement cyber plans as well as help them manage and recover from data breaches.
And this episode is brought to you by Red Clover Advisors. We help companies to comply with data privacy laws and establish customer trust so that they can grow and nurture integrity. We work with companies in a variety of fields, including technology, e-commerce, professional services, and digital media. In short, we use data privacy to transform the way companies do business. Together, we're creating a future where there's greater trust between companies and consumers. To learn more and to check out our new best-selling book, Data Reimagined, Building Trust One Bite at a Time, visit redcloveradvisors.com. Ready for some fun? You were still wearing the big crazy, so anyone who's watching can see our strange shirt situation you got going on here.
I don't understand. I'm wearing a hoodie. You wear hoodies all the time.
Super thick. It's as if you have like a massive scarf thing around your neck.
Well, I'm
very warm.
I'm yearning to go back to Colorado.
I see. Yes. Well, back from spring break, back to the real world. We're going to have a good discussion because today we have Al Saikali, who chairs the privacy and cybersecurity practice at the law firm of Shook, Hardy and Bacon. For the last 6 years, Chambers USA has recognized Al as a nationwide leading practitioner in privacy and data security law. And under his leadership, he was named Shook was named the Law 360 Practice Group of the Year for Privacy and Cybersecurity, and Legal 500 has named Shook a top cyber law firm for the last 5 years in a row. So congratulations on all those amazing accomplishments, and we're really delighted that you're here with us today.
Thank you, Jody, and thank you, Justin. Great to be here.
It's really fun because we've had all kinds of LinkedIn conversations. And it's always nice to see people, outside of the social media world.
Yes. Yeah, that's right. Right. In fact, sort of IAPP, you and I met, it had to have been about 10 years ago as one of those 5-minute mixers. I think they still do it at the IAPP.
I think they do.
Right. So this is a lesson to everybody. Attend the IAPP 5-minute mixers because you never know. You meet somebody and then you still are in connection with them 10 years later. So, yeah.
Exactly.
Thank you for inviting me to be part of the show.
Why are you laughing?
Just reminds me if he could have said, you go out to a Wednesday night drinking club, you never know who you'll meet.
You're going to have to explain that story. You can't just leave that one there.
I guess for the benefit of Al and our audience, Jody and I met one night on a rainy night where you typically wouldn't go out to a drinking club where we really don't frequent. And I guess to your point, Al, what you were saying is I went somewhere, I didn't anticipate much happening. I kind of went on a lark and you meet the person who turns out to be your wife. So there you go.
It's true. But in the spirit of, if anyone's ever done like speed dating kind of things, the speed networking at IAPP, it's really well done because you get just a couple minutes to meet a whole bunch of people. And then you can stay in touch with them and have a podcast and have a conversation.
There you go.
That's how it works.
All right. Yeah. Well, let's get back to
our regular schedule.
Scheduled programming. So Al, can you tell us about your career and how you got to where you are today?
Sure. So I've been practicing law now for 24 years. I started as a judicial law clerk and began my career as an appellate lawyer, focusing primarily on product liability issues. And then I joined Shook in 2005. And for about 5 years, continued working in the area of product liability litigation, but really focused on all levels, trial and appellate. And then as I came up for partner, that was when I started to make the transition into privacy and cybersecurity. I'd always been interested in technology ever since I was a little kid. And it was just something that continued to interest me. So I started doing research on different areas of the law that were out there that are new or novel and could have a strong future. Because honestly, everybody in my firm was doing product liability litigation. And I kind of also saw it from the business perspective of, if you're going to become a new partner, why is someone going to hire you versus someone else who's been doing this for 20 or 30 years? Like, you got to find a niche that really works and that you're interested in, that's going to sustain your career in the long term. So I started a blog, which is still going today. I don't write as much as I should, but it's still going today. I speak. I started speaking and just writing and trying to get my name out there and learning about privacy and cybersecurity. And then the big sort of bump in my development in the area came in around 2012 or so, where there was a small company that had a data breach that was a very significant data breach that impacted about 300,000 people. And they came to me and said, we need your help. And I quickly realized there was no way that they were going to be able to afford our big law firm rates to be able to do that kind of work. And so I sort of negotiated a deal that is almost allowed us to do the matter for pro bono. But as a result of that, I got experience sending notices to all 50 states and to the AGs, and working with AG inquiries and developing templates and models and things that I could use in the future. And then by chance, within the next few months after that, we started getting inquiries from existing clients saying, do you have anybody that does privacy and cybersecurity law? Because our typical firm just doesn't have anyone yet. This was back early, even before the Target breach, I think. And so we started getting hired more that way as well, and started slowly grow. And it grew from me to a team now of 34 lawyers in different offices throughout the country. So that's a little bit about my background.
So Al, I actually wanted to ask you a follow-up question for maybe our legal listeners. Is, you and I are both cybersecurity practitioners, but by trade, I'm a transactional lawyer and you are a litigator. And I'd love if you could share with our audience a little bit about how that litigation background influences how you approach cybersecurity and privacy issues.
Yeah, no, that's a great point, Justin. I think about it when I'm handling an IR matter. I'm very much always thinking about, where is this going to end up in litigation? Like, what are the factors that a plaintiff's lawyer is going to look to as part of the incident? Because you want to obviously try to mitigate the likelihood that there will be a class action lawsuit, which is getting increasingly more difficult these days, because the bar for filing a class action lawsuit is just getting lower and lower. Now we're starting to see them following data breaches that impact as few as 1,000 people. But thinking with the litigation mindset, you are always thinking about, what should we be saying in these notices to make sure that they're accurate, because you don't want to create a potential negligent misrepresentation or fraud claim. What should we be doing in terms of providing credit monitoring or not, because you're thinking about that in terms of the standing or harm arguments that would be raised in litigation. You're thinking about the class size, because that's also a factor. So it's been very helpful to the IR side of our practice, I think.
Now, Al, you're located in Florida, and Florida is in the news a lot for a variety of different reasons, but we're going to talk about privacy
Not always
today.
good, right? That's right, yeah.
And you always do a wonderful job of summarizing what has been introduced, what some of the big issues are in Florida as it relates to the different privacy laws that have been introduced over time. I was hoping maybe you could share a little bit about, what are some of the issues? Why hasn't it passed before, which many people thought it was going to? It was hanging on by a thread, or some people could say by a chat. We went all the way back.
Or we could say it's hanging on by the privacy right to private action.
We're going to let Al share with us a little bit about what has happened.
Nipples are hanging, take it away.
Right.
And where we might be going.
So there have been a couple of attempts in years past to pass a more comprehensive privacy law here in Florida. And for those who are not familiar with Florida politics, it is a pretty much supermajority Republican state now across the board, which has been a big shift over the last, decade or so. But it's a strong shift. I mean, the Republicans are in the governor's house. They own the House of Representatives and the Senate in our state legislature. So as a result of that, it's been very difficult to pass a comprehensive privacy law that has a private right of action, for example, to Justin's point, which would allow individuals to file more and more lawsuits. But it's been an interesting dynamic because privacy is not an area that really cuts like Republican Democrat as much as it used to, right? Because, and I hate to kind of use the overgeneralizations, but it used to be the case that the Democrats, being very pro-consumer, were very much in favor of a comprehensive privacy law and still are. The Republicans, typically being more pro-business, would oppose many of the requirements that the comprehensive privacy laws would put, on potential businesses, claiming that they create significant costs. And so there was a lot of opposition. But within the Republican Party now, there's been much more of I call it a fracture, but there's this divide between sort of the very populist movement and the pro-business side. And so the populist movement is very much in favor of these kinds of laws. But even within there, they're still, I don't think, entirely on board with the private right of action. So the private right of action had been a big problem in years past. And I think it really came down to the leadership in the House and the leadership in the Senate. There was an individual who was leading the House who was very much on board with a strong privacy law that would allow for private rights of action. And he wanted to be able, I think, also use that after leaving his position in the House in going into private practice. The Senate side, though, they're much more traditional here in Florida, and they're very more pro-business. So it never really got through the Senate. This year could be a very different story because the bills that are before the Florida legislature this year are very focused on big tech companies. I mean, the scope in terms of how it defines what a controller is, essentially any company that earns more than $1 billion and either provides targeted advertising services or manufactures smartphones or smart speakers or contracts for the manufacturing. You can tell they're going after Meta, Apple, Google, like the really big tech names. And I have not been involved in the effort this year as I have in years past because I'm not a fan of what is happening. I don't think that this is the way you go about developing a privacy policy, is using it essentially for political purposes to target some specific companies. The law does not have a private right of action built into it, or the legislation doesn't have that private right of action built into it. But because it's very focused on a few companies, there's a very good chance it will pass, because in years past you've had the lobbying arm of smaller and mid-sized businesses that were opposing it. So we will see. The session ends, I think, mid-April. So we'll see if this comes about, but it's certainly something that I think has a very good chance of passing the legislation.
With that being said, do you anticipate or have you heard anything about any other privacy laws coming that might, affect all the other companies that are out there? Or you think at this point, just Al's view, that it really is going to be, the likelihood is this bill for the really big companies, and maybe it's future years where there'll be something that kind of addresses the masses?
Yes, I think it's the latter. I think this year it's just going to be the bill that focuses on big companies. But my concern is if this passes, it essentially will turn into a tax, because there'll be a lot of enforcement actions and that will seek millions of dollars. And then the cost of using Google and Meta and those services for advertising that a lot of small businesses enjoy and really like, that's going to go up because the cost will just get passed down to them, I think. And you're just one minor tweak away from applying this law to other businesses. You just have to change the definition of controller a little bit. But in terms of what else we could see changes to the FTSA, which is the Florida state equivalent of the TCPA. It's like our little TCPA Act. And there have been a significant number of class action lawsuits filed in the last year or so due to some changes to that law. So we could see some corrections there. I'm also hearing rumors about the legislature addressing what's going on with wiretap claims, because there's just so many of these wiretap lawsuits now in the privacy space that they're talking about, do we need to change the wiretap law, the FSCA, here in Florida to make it clearer that these sorts of lawsuits should not proceed. So that would be something else to watch as well. But the first one is the one I think is most likely to pass.
In that vein, I know we were going to talk about there's so much happening with class action lawsuits. I'd love to dive in a little bit more on the kind of Florida version of TCPA and the wiretapping piece. If you can share maybe what you're seeing in this future bill, or really what are a little bit of the details of the types of cases that you're seeing and what companies should be doing and thinking about.
Yeah, so the wiretap claims are, I think, the hottest area in privacy litigation right now. And these are usually arising from the use of certain advertising technology and websites. So let's say I'm a company, typically it's a healthcare company that is often a target, but it can be anyone that uses videos in a website for sure. But if I'm a company and I use pixels in my website, or if I use session replay in my website, and that results in the sharing of my information with a third party. For example, when the way let's take pixels for example. The way the pixel technology works is when I sign up for Facebook, I am told by Facebook that we are going to give you put a cookie in your browser, and that cookie is going to track where you go around the internet. And the reason for that is so that when you come back to Facebook, you will see targeted advertisements for the places that you visited. And that information is shared with us by you as a result of the cookie that is placed in your browser. And so as I go travel around the internet, and many are arguing that people don't read those sort of notices. Right. So it just happens and they go on about, and some could argue, well, that notice may not be enough, but regardless, that's what happens. So then when I go to a website that has what's called a pixel or the metapixel built into it, that my browser sees that and says, okay, I now have to send information about this visit over to Facebook. And it will send information like my Facebook ID and the header information for the website, things like the URL that I'm visiting. And sometimes, depending on how the pixel is configured, it can send information about things that I type into the website, like in the forums and things like that. And so there have been a number of lawsuits now that are claiming that there hasn't been a sufficient disclosure by the website about the use of the pixel. And so the website is causing information to be shared with Facebook about the individual. And this becomes particularly problematic for healthcare providers. Because under HIPAA, if you're going to share PHI with a third party, you need to make sure that there's a business associate agreement in place. And so a lot of these lawsuits are against two kinds of entities. One are the healthcare providers, where the argument there is that because the pixel sometimes is even in the portal, the patient portal, but is just maybe elsewhere on the site, it is shared PHI with Facebook about me. And there wasn't a business associate agreement in place, and I didn't give them authorization to do it. So I'm considering that a breach, and I'm going to sue you now. And I'm suing for a violation of the wiretap law because there's an interception of my communication with you by a third party. And now, as a result of that, I'm entitled to $1,000 in damages. And each person should get $1,000. So that everyone who visited your website should get $1,000. And so that's basically what these lawsuits are alleging, and they're in the new phase, right? These are last 3 to 6 months is really where we've started to see these things pop up. But they are, we're seeing 2 or 3 new ones getting filed almost every day. They could end up being like the new BIPA, except it's just nationwide. The other, I talked about it being in 2 scenarios. The second scenario where we see it, though not as much, is with the VPPA context. And there, the Video Privacy Protection Act context, companies will sometimes put pixels in videos. And as a result of putting the pixel in the video, it could potentially share information about the video or what I watched, the kind of video that I watched, again, with the third party. That's the allegation being made by the plaintiffs in these cases. And the VPPA prohibits the sharing of video watching habits with any third party without consent. So to your question, Jody, about, okay, so then how do companies try to mitigate this risk, or what should they be doing? I think a big problem is that the lawyers in the companies aren't talking to the marketing people in the companies. Half of our clients didn't even know they were using pixels, right? They don't know what it does. They didn't know anything about it. And it's only now that they're starting to learn more and research into how it works. So number one, I think, is having that conversation to figure that out. And then number two is, what are the privacy controls that are existed? Because with pixel technology, there are privacy controls. There are ways you can limit what potentially gets shared. So thinking about how are we maximizing those, and are we sharing the minimum necessary with the third party? I think the third thing is thinking about, from a litigation standpoint, do we need to have like an arbitration provision potentially in place? Do we need to be thinking about getting cyber insurance, something that will cover the cost of these sorts of lawsuits as they pop up? So for sure. But the other big thing too is disclosure, right? Disclosure and consent. Put something on the website, like a pop-up when you go to the website, and the marketing departments hate that, but a pop-up that says, we use technology that may share information about your visit with our site with third parties. To learn more, go to our privacy notice and then have a link to that. But it has to be the pop-up. You can't just rely on it being on the privacy notice at the bottom, because courts have held that the recording in session replay or the use of the pixel has happened the moment that you hit the website. So you've got to have that pop-up right away. So those are a few tips, I guess, in terms of what we're telling clients to try to mitigate some of those risks.
So Al, I kind of have an interesting question as a follow-up. You just triggered something in my mind, which is with the proliferation of these lawsuits, kind of using existing laws that are now being applied in new ways, and given that, Republicans are typically pro-business, could you talk a little bit about what potential implications could be? Because lawsuits sometimes drive new laws, and perversely, it sounds like if we continue to have a rise in these kind of wiretapping or VPPA claims, could that not be an impetus to see more privacy laws as a response to this type of litigation?
You could, we see it in congressional hearings, the U.S. congressional hearings, right? Like there's this anti-big tech attitude that pervades Congress in both parties. So there might be some legislation that's passed that is very targeted in that way, the same way that Florida is trying to go about doing something like that now. So we could see more of these laws being passed. I think on the other side, Drew, though, you're also seeing a recognition by legislatures and leaders that maybe this is going too far. And one of the examples of that recently is the BIPA decision out of the Illinois Supreme Court that allows individuals to sue, $1,000 per violation, and has now, or $5,000 if it's intentional, but has now, the Supreme Court has held that you measure that based on the number of times a person provides, for example, a scan. So when you check in to work, when you take a lunch break, when you come back, when you go home, 4 times in one day, that's $4,000 for that one day, multiplied by the number of days you've worked there. It's just insane levels of damages that will bankrupt companies. And I think there's been, I think, a fairly strong reaction, like that's not the right result either. So there has to be this like middle ground, like what's it going to be? If there is going to be a private right of action, how do we make sure that there's not some bankrupting type damages as a result of that because of the statutory damage? And so maybe a middle ground is requiring some proof of harm in order to be able to pursue the statutory damages, though then that raises the question of, well, what does that mean? Like, what is harm, right? Like, how do you define that, especially in the privacy context, right? And that's a big discussion. So, yeah.
Al, you mentioned having the pop-up disclosure, and I wanted to ask, in your mind, is it enough to have just the disclosure? And, there's kind of the opt-in versus opt-out approach, meaning, can I have the disclosure, the cookie still fires, and then if I say reject, then you won't fire me anymore? Or does it need to be, in these types of situations, the banner that allows me to accept and the cookie only fires when I hit accept?
So I think for now, having the disclosure there is going to be enough to avoid most of the rounds of lawsuits that we're seeing, because I think right now the plaintiffs, the plaintiffs bar is picking up low-hanging fruit of companies that have nothing there at all, usually not even a privacy notice on their site. But what you're hitting on, Jody, goes to what I think is the future wave, like the next 6 months to 2 years of lawsuits we're going to see, which is how well are companies complying with what they're saying they're doing with respect to cookies and giving users control over that. So, for example, when I visit a site and I have, my GPC, I'm sending signals to the website saying, "Don't track me, don't give me, I don't want any cookies, don't share my information." A lot of companies are ignoring that. Similarly, even with the cookie banners, and when there's granular options that you can pick, I want these kind of cookies, but not these kind of cookies. Companies are sometimes ignoring that too. It's not like an automatic thing where it's done, it's just automatically, deployed. So what I think will be the next wave will be these negligent misrepresentation, fraud, consumer deception, deceptive trade practice type claims that will come about, arguing, look, you told me you weren't going to collect my information or share it. You told me you were not going to install cookies on my browser, but you did. And that is a violation of these laws. So you're going to start seeing those lawsuits too. And that's a whole other world of hurt. So it's, I guess, the underlying point or takeaway for listeners, I think, is making sure that what you're saying you're doing on the website is actually happening as people visit it.
It'll be interesting to really see what happens, because as we all know, the acceptance of those cookies. So if it really moves into a future of you can only have it fire if I hit accept, there's going to be 3 people left. And so then the technology doesn't work, which maybe is the goal. Well, the goal is probably just to get a lot of money from the people who are filing the lawsuits. Or maybe they really do have a mission and they don't genuinely like the technology. But it will be really interesting, I think, to see where that goes. Because we've seen what has happened to the ad tech industry in GDPR, right? The levels of consent are very small.
Yep, absolutely. Very true. That's very true.
You were very eager, Justin, to ask a question, and I made you wait.
I guess the other thing I wanted to get your perspective on, Al, is, you just said, a lot of companies, you can have a privacy policy, but if you don't comply with it, you open yourself up to this litigation. You also made a very good point about how marketing and legal don't talk. But it sounds like in order to really have a privacy policy and do what you say you're going to do, not only do these two folks have to talk, but now you got to add IT, because they're the ones who
100%.
technically have to do it. And, what are your thoughts around that? Because that all 3 of those parties speak very different languages, and now they have to come together as a cross-functional team.
That's exactly right, Justin. And I would even throw one more in there, which is your third-party website developers, right? A lot of companies don't actually develop these websites themselves. They hire third parties to do that. So you do have to bring everyone to the table. And, I guess in many ways it goes beyond, we've been talking about the website as an example, but it provides another example of why you want to bring HR into the conversation with privacy, because they're obviously handling and dealing with a lot of personal information about employees, and maybe thinking of rolling out certain technology or doing certain things that might impact that personal information. So there should be, all the stakeholders at the table together. And, one of the things that we've been doing with clients is having quarterly meetings with their legal folks, and they will invite other stakeholders to that call just to give them an update of, here's some trends we're seeing, some things that are happening out there. And that will trigger the conversation of, hey, you know what? We're talking about session replay here, but we like to use session replay to get consent for TCPA type actions. And so we've been using it a different way. But in light of this conversation, maybe we need to think about whether we have sufficient disclosures. So at least setting a quarterly call to talk about these kind of things and get everybody familiar with these trends, I think is pretty important. So,
what are you seeing as it relates to chatbot class action suits? Right, there's a lot of websites that will have a little chat vendor that pops up on the website, so I can talk to them at all hours of the day. And it's my understanding that you're seeing similar class action suits with that technology.
Yes, and it's the same sort of thing. They're wiretap claims, and the argument there is when Al visits the website and that chatbot pops up, it's being provided by a third party, but I don't know it's a third party. So as I type in communications to the website, the company behind the website, I'm in fact, that information is actually being shared with the third-party chatbot service provider, but I'm not aware of it because there's never been a disclosure. So there is essentially an interception of my electronic communications, and it's not disclosed to me. It's surreptitious, and therefore I get $1,000 for finding that and calling it out, right? And everybody else does too that uses it. And so that's been going on. Now in Florida, we were able to obtain some pretty good decisions from federal courts that said that's not really what the wiretap law was meant to do. Also, is this really a device or content under the statute? And there's some sort of technical arguments that were made that were successful, but that's not the case everywhere. California, the defendants are having a really hard time out there, and there are 2 plaintiffs firms there that are just going about sending out demand letters to every company doing business, alleging that there's technology on their website that violates the CIPA, which is the California wiretap law, and looking for a quick payout in order to go away. And so, the litigation continues. But yeah, that's another way in which the wiretap laws are being used, is with the use of this chatbot technology.
So, Al, knowing what you do and all of your years practicing in the privacy and security area, if we were hanging out at on Miami Beach in South Beach, what kind of best privacy tip would you offer to me as we're hanging out drinking a tequila on South Beach?
Well, one of my first mentors in privacy, Chris Wolf, would probably be there because he loves coming to Miami Beach and enjoying it. And so I think, look, one of the things I tell like family members is don't share so much of your personal information. Don't overshare, and you have to assume that when you share it with a company, that company's probably going to end up sharing it with other people, and then you lose control over it. So assume that whatever you give someone, that then gets given to other people as well. And one of the ways this comes up a lot is, cell phone numbers. Like you go everywhere and somebody needs your cell phone number. I parked the car, and then the valet guy's like, I need your cell phone number. You go to a restaurant, like, I need your cell phone number in order to text you when this is ready. Like, oh, is the cell phone numbers here? And then people are wondering why they're getting calls all day long, from numbers they don't recognize. They're giving the number out to everybody. So, you could create a different number, or you could change a digit, whatever you're going to do. That's one area that's something that I certainly may or may not have done over time. But yeah, that's something else that I like. A little practical pointer is watch out for giving out too much information.
Al, am I going to have to depose you now over what numbers you've been giving out?
Somebody out there with one digit different from mine is getting a whole lot of phone calls.
Well, they're going to be happy because then they're getting your table.
Right, that's true. Yes.
So Al, when you're not working on all things privacy, what do you like to do for fun?
Well, people just kind of vegging out and watching TV. The weather here in Florida is pretty good, so we enjoy our pool most year round. But yeah, no, I've been watching. Let's see, these days I've been watching. What I've been really hooked on is a fantastic show, is Drive to Survive on Netflix, which I was never a Formula One fan. I could care less about it. Didn't know anything about it. But this show, I went through 5 seasons in 3 or 4 weeks. It's fantastic. That's a good one. I just finished Last of Us. This weekend I watched that one. I don't know. Yeah, kind of watching TV, relax. Oh, I will say that I'm trying to do a much better job this year of reading for fun. I don't do enough of that. I haven't done enough of that. So this year I'm starting. I went to the New York Times bestseller list for last year. I'm like, okay, let me work through some of these. Let me work through some of these books. I'm like, they've got to be picking them right? It's probably so. So I started. I will tell you, I had a fantastic one that I found. It's called Trust, and it's a guy written by an author named Hernan Diaz, and it is fantastic. So if anyone's looking for a good book to read, I would highly recommend that one. It's very good.
Thank you for sharing. Where would be a great place to connect with you if people want to learn more and follow you?
LinkedIn. I post a lot there on LinkedIn, so feel free to reach out, make a friend request. Also my blog, I'm trying to write more. I don't do it as often as I should. That's the privacy and data security law journal.com, and maybe on Twitter a little bit, but we also send out alerts. So if anybody wants to learn more about developments in the law, just shoot me an email. We'll add your name to the alert list that we have here at Shook. And I'm look forward to meeting more people in the privacy community. I'm always at the conferences, as you know, Jody. I'll go to the IAPP and Net Diligence and some of these others. So yeah.
Well, Al, thank you so much. We really enjoyed the conversation.
Thank you for having me. I appreciate it.
Thanks for listening to the She Said Privacy, He Said Security podcast. If you haven't already, be sure to click subscribe to get future episodes and check us out on LinkedIn. See you next time.